thousand. Oh, do you need to go somewhere?
No, Judge, I was just gonna step out, just to talk to the detective. I think he's out in the hallway, but I could do that really quickly.
Okay. Court is going to call 2021 CR 5583, State of Texas versus Carlos Romero. Could I have parties announced for the record for the state?
Hank Wilkins and Daniel Escobar for the state.
Defense?
Cornelius Scott, Bridget Garza for the defense.
All right. And are you Carlos Romero?
Yes, ma'am.
All right. So where we left off is the state you had offered into evidence, state's exhibit number 24.
Yes, yes, ma'am.
All right. The court has reviewed states. Before we get to that, there's a part that is objectionable. And that part in state's exhibit number 24 is where, and I want to say the timestamp is at 6:35, where the officer mentions Mr. Romero's history. So I will, of course, not consider that. And that should be redacted. But since this is a bench trial and not before the jury, I just want to let both parties know I'm going to disregard that. I did listen to the entire state's exhibit number 24, and there's a portion in it, and it's the end of it, when Mr. Romero says he does not wish to speak anymore and that he wants an attorney. And after that, the officer leaves the room after that is requested. Now, Mr. Cox, did you have objections to state's exhibit 24?
I still have objections to it, Judge, and what I'm asking for the court to defer the entry of the exhibit until the officer testifies again. He's going to
So,
testify.
I mean, he's previously testified. Are you saying that you wish to take him on voir dire with regards to state's exhibit 24?
Correct, Judge. If I can do that, that'll be fine. That'll be even better.
All right. I believe that's been done before, but I'll allow defense to take the witness again on voir dire. Could you have your witness come back?
Yes, Judge. Really quickly though, so do you want me to give you a redacted copy of States 24? Because I could do that. I was in the middle. I think you said at 6:35 is roughly when you wanted it.
Yes.
I was gonna just do that very quickly, but it'll take me a second to get it burned through this.
No, we'll just label it as 24A, whatever. If the court decides that it comes in, we'll just label it as 24A, and we can do that once the officer finishes his testimony, because I know he needs to be somewhere else.
Well, I think today he wasn't on leave, it was training. So.
Okay. And since it's the court, and I've already said that I'm disregarding that portion anyway. No, we're not. They're here today. And so I'll talk to him. All right. Could you state your name again, please?
Mark Morales, Morales.
All right, you're still under oath.
Yes. Your
And
Honor.
the state had passed you as a witness, and the defense wishes to take you on voir dire.
Okay. Okay, can I proceed now, Judge?
Yes.
Detective, you testified in this case last week, correct?
Correct.
I just want to make sure you're the same Detective Morales that testified last week. Now, what I want to do is ask a few more questions. The warrant in this case that you had for my client, were you the officer that actually acquired that warrant? You the detective?
Correct.
Okay. And when you applied for the warrant, you weren't in a situation, it's fair to say, in a situation where you were able to like go out that day and apprehend my client, correct? You didn't take him into custody that same day?
Correct.
Okay. Now, it appears and you can correct me if I'm wrong, that that my client was actually in another jurisdiction when you took the statement from him, correct?
Correct,
Okay, and that was Kamal County,
correct.
Kamal County Jail. Okay. Now, do you recall whether you contacted Kamal County or they contacted you when my client was placed in custody by them?
He was being followed out of San Antonio,
Okay, he was being,
and then they told me that he was under arrest.
okay, all right. So when you say he was being followed outside of, followed out of San Antonio, who was he followed by?
Or rope unit,
Okay, so,
repeat offenders,
I'm sorry,
repeat offenders
Okay.
unit. At the time, that's what they were called.
so it's fair to say that Rope had established some type of surveillance on him? Or do you know?
I believe they were contacted back and forth. They were trying to get surveillance on him, and by the time he made it into Comal County, they had to let him go. And I believe someone else picked up the traffic stop. I believe that's the way it went down.
Okay, now were in terms of Rope's information, in terms of how they got involved in trailing him or surveilling him, did you provide information to Rope?
No,
Okay. So in terms of when Rope acquired on this day, when he was stopped, when Rope acquired the surveillance of my client, were you made aware of it?
I was made aware by I believe a state trooper that stopped him. That's who contacted me, relaying the information that they were trying to get to your client, our guy's rope for, and they contacted the next jurisdiction over.
Okay. So the basis for the initial stop of my client, was it based on the Rope surveillance? Was it
You would
based on
have
the
to
trooper?
contact the trooper on that. I
All
was
right,
not.
so I'm sorry to
involved.
interrupt. So everyone, just remember, court reporter can only take down one person at a time, so let them finish their question.
Sure.
Then they'll let you finish your answer. Could you repeat the question, Mr. Cox?
So the basis for how my client's vehicle was stopped, was it based on information? Was it based on the trooper by himself? Was it based on Rope? Or was it based on information that you relayed to?
It wasn't on information I relayed to him. Whatever the stop was for, you would have to contact the trooper that made the stop.
Okay. So was there any correspondence between you and Rope as they were following my client out of the jurisdiction?
No, sir.
So your testimony is that you didn't realize that Rope was surveilling?
No, sir.
That information would reference Rope surveilling my client, the surveillance. Was that a part, did you make that a part of your file?
I'm gonna object to relevance at this time, Judge.
All right, that'll be overruled. You can answer the question if you.
What was the question, sir?
Question was that in your testimony, the information about Rope having a surveillance on my client, did you make that a part of your case file?
No, sir.
Did you ever have any conversations with these rope officers?
No, sir.
When did you become aware that rope had this surveillance and had followed him out of the county? When were you made aware of that?
The DPS trooper called me when I walked the capital murder warrant, and I attached my phone number to it. He called me once your client was arrested, and rope they were trying to catch up to him. They never got on surveillance on him. They were trying to make it to him before he got to Comal County.
Now, the DPS trooper, you recall who his name?
No, I don't, sir.
Would that be reflected in your case file?
I'm not aware if it is. He would be on a booking slip with Comal County. He's the trooper that booked him there.
Would it be a part of your case file?
No, sir, it wouldn't be part of my case file.
And how many conversations did you have with that trooper?
5 seconds, maybe 10 seconds to tell me that he was in Comal County.
Okay. So in terms of, but you don't know who the trooper is, you know his name?
No, sir.
So how does the trooper in Comal County, did he call you directly?
As I said, sir, my number was attached to the capital murder warrant. If he was arrested, to make contact with me.
Okay. And that trooper made contact with you,
Yes, sir.
and then once he made contact with you, you left Bear County and you went to Comal County.
Correct.
So when did you have that conversation with that trooper? What time was it?
It's after lunch. I know that. I couldn't.
It's
Be
not
specific.
reflected in,
No, I couldn't tell you that correct time.
so you would make a note of that you got a call from the trooper.
No, sir.
And now, based on information, do you recall whether you called Comal County before you went up there? Or did you just go up there and once you got up there, you presented yourself?
No, sir. I called Comal County to see if it can be arranged for me to interview your client.
Okay, so you call Comal and ask for them to arrange for you to meet with him before you even left to go up there, correct?
That is correct.
Okay. Now, who did you contact?
Whoever answered the phone at the Comal County, sir.
You
I
didn't-
don't have her name.
You didn't take any information
No, sir.
from her? Was that information in your case file?
No, sir.
Now, once you got to Comal County, did you present yourself to any particular officer, or you just went up asking for the lady that you talked to on the phone? What happened?
I walked in the door, buzzed my way in. I entered, secured my weapon, and I asked where I needed to go for an interview.
From the time that you spoke to that trooper on the phone until you actually reached Comal County and were beeped into the jail, how much time elapsed? How much time?
Maybe an hour, hour and a half.
So when you go out of county, you don't have to alert somebody that, hey, you're leaving county on something, the time, you don't get timestamps on those types of things?
No, sir. I just advised my sergeant at the time telling him I had to go to Comal County.
And you had to tell your sergeant why, correct?
Sir?
You had to tell him why you had to go
Yes,
to
sir.
Comal County? And he had to, would he have to give you the okay to go?
Yes, sir.
Okay. Is that information in your case file?
No, sir.
Now, I think I asked you before, and I think it was on Friday. Did you try to make a determination as to whether or not my client was already represented by a lawyer?
I'm gonna object to ask answer.
All right, that'll be overruled. You can answer the question.
Question again, sir?
Did you, prior to leaving, go to come out, make any type of determination?
No, sir.
To see whether he had a lawyer?
No, sir.
Now, when you got to the Kamal, did you inquire of any of the administrative personnel or jail personnel whether or not my client had been magistrated yet?
I believe I asked if he's been magistrated and I don't think they said no, I believe.
Okay, so you would ask why he was, if he had been magistrated. And they told you no. And at that point, you go and you attempt to do the interview with him, correct?
Yes, sir.
Come on. I pass witness, sir.
All right, stay.
Nothing for the state judge.
All right, is this witness excused?
Yes, Your Honor.
Yes,
All right.
Judge.
My excuse for the rest of the remainder.
You are excused for the remainder. Both parties have
right.
excused you, but remember the rule has been invoked.
Yes, ma'am.
All right, thank you. All right, and state with regards to State's Exhibit 24, and we're going to label it as 24A,
Yes, Judge.
and defense 24A, which the state is going to put together.
Okay.
But they don't have it together yet.
Yes, ma'am.
The state, the court is stating that at 6:35, if you all can look at it.
Judge, I was gonna ask if you could do me a favor, there's a number at the top right of the video, if you could tell us what that number is.
Well, I tell you what, if you all will put it in the player, and at the bottom, the line at the bottom, at 6:35, there's mention of history.
Okay. And then what I was gonna do was just end everything at that point, and then that would be it.
Well, if you all will see, other than that, and I haven't ruled on the admissibility of it, but other than that, if you all could please check to see if there's something else that is objectionable. So that's the only thing that the court saw when the court was listening, is the mention of some type of history. All right, so while you all do that, we're going to take a short recess. So then once that's redacted out, you can offer it and then I'll hear argument.
Yes, sir.
And that'll make the record easy for the court reporter.
Okay.
Can you read this and All right. So state you're offering State's Exhibit 24A,
Yes, Judge.
defense,
Okay,
and you can remain seated.
all right. Judge, my objections are many, and it goes to the entirety of the statement.
Mhm.
The officer himself testified that there appeared to have been some type of surveillance that was set up. So I'm from the beginning on my client. He was being followed. We don't know who authorized it or whether there was some type of judicial authorization for them to surveil him. We don't know that part of it. And it appears that somehow he gets out of the jurisdiction of Bexar County, and then he's located or stopped by a trooper, DPS trooper. Now, that information, the officer testified to, is not part of his file. Then what happens is that he gets a call from this trooper, and he doesn't write into that thing. The trooper tells him that I would imagine that he's taking him to Kamal jail. Now, I'm not sure at this point what probable cause the trooper had to stop the vehicle. We don't know because nobody included that part of it. In my position, Judge, that when we talk about a motion to suppress a statement, I think the court would have the duty not to just get to the part where they, like the officer detective says, he's an artist. He states that in the video, not the part that he choreographs. But I think the court needs to look at the whole picture, not just his picture. So what happens? He has a conversation with the trooper. Then the detective has a conversation with his superior about going to come out. None of that's in his report. So he makes a call. He sets up the interview. None of that's a part of his report, the officer's report. And then just as soon as he gets to Kamal, then he hits a little button and they just open the doors, he come in, and now he's gonna do his interview. Now, as far as the officer is concerned, all the things that led up to it, we don't need to know about that. We don't need to know about that part. The only thing we need to know is when they open the gates, he walks in and he's directed to a room. Now, there's a question. The officer was asked this afternoon, did you determine or did you ask whether or not my client had been magistrated? He said he believed he asked and he believed that the answer was no. My position on magistration is that the magistrate is a neutral person that comes in and part of the, if a person is in jail, then a part of the magistrate job is to magistrate everyone. So in this case, he sets up this detective Morales. He sets up this interview. It doesn't matter to him whether or not my client was magistrated. by a neutral magistrate in the jail. They just open the doors. Now he's talking to them. And if you, bless you, Judge, if you look at the tape, he never on the tape says, look at son, you're charged with capital murder. But what he does is that he starts telling him, start giving him legal advice. Well, what stands between, if he comes to court, I want to be there, and in the prosecution, they're gonna seek the death penalty on.
All right, and counsel, I've seen the video.
Okay,
Okay.
all right, I'm just highlighting, but I'm
Mhm.
sorry. So my position, Judge, is that in terms of, and I know that the officer ran over, oh, you got the right from inside, yeah. My position, Judge, is that it goes beyond that. What happened prior to that is something that should have been made known to my client's attorney, to us. We should have known that he was followed. What was said to the trooper? Why did the trooper stop? Why did they bring him in? We should have known that information also, Judge. My position is just based on the totality of the situation, that this statement, not circumventing the magistrate, that this statement was not free, involuntary. The officer never asked what led up to what happened. Did any other officer take any fresh, no, none of that. The officer said he was an artist, saying what he did, he painted the type of picture that he wanted. He left certain things out, so we couldn't investigate it. My position, that Judge, is that this statement comes in and is a violation of my client's rights. And we feel that the statement should be suppressed, the whole statement.
All right, that will be denied. State's Exhibit 24A is admitted with the redactions that the court requested. State, call your next witness.
State rest, Judge.
Defense,
We rest it.
state, do you close?
Yes, Your Honor, rest and close.
Defense, do you close?
We close, Judge.
All right, court will hear argument. State,
Your Honor, we reserve our time for rebuttal, Judge.
all right, defense, the court will hear argument, and you all can remain seated.
1 second. It would please the court, Judge, we're at the end of the trial now.
Mhm.
And we heard from several witnesses. And I feel, based on the evidence, one of the important witnesses was the fingerprint exam when she testified on Friday, and her testimony from, say, maybe 2 weeks back. I asked her the question, ma'am, can you determine how long or how long a fingerprint has been on an object? Or could you determine the age of a print? And she said, no. I asked her, could you tell whether it's been 2 months, a year, 2 years, 5 years? You remember the statement? And she couldn't tell. She could not make that determination. She could determine whether, based on her expertise, whether or not the print was made by a person. She can't tell when it was made, or where it came from. My position, Judge, is that the standard, even in a bench trial, is proof beyond a reasonable doubt. They charge, the state is charged by client with burglary, and the mere fact that a print was found on an object inside the residence without any timeline as to when or how or whether before that, even as they was placed there, they don't know. There's no explanation for it. Our position is that the state has failed to meet their burden to charge them with burglary beyond a reasonable doubt. And I think that the only just verdict that's consistent with the lack of evidence in this case for burglary is a verdict of not guilty.
All right, state.
Your Honor, may it please the court, well, we heard from several officers in this case, so just to refresh the court's memory, we heard from Officer Lesperais, who was the first on the scene. He went to the apartment, did a protective sweep. He saw the pry bars and the wrenches in the bedroom safe. He saw that the bedroom safe had 3 bullet defects in it. On his body cam, we could see that in order to get to the safe, he had to go through the living room, through the bedroom, through the bathroom, into the very back of the apartment to the closet. Next, we heard from Officer Trevino. He went to Kelbron's apartment. He saw that the door was damaged, just as if somebody had broken in. He saw that the apartment was ransacked. We heard from CSI Sarabia, who collected the evidence at the scene. He took the photos of the scene. He took the latent prints off the safe keypad. We heard from the latent print examiner. She testified that the fingerprint on the keypad matched the defendant here in court. And then last, we heard from Detective Morales, who testified, and we saw from his body worn camera that the defendant told Detective Morales that he didn't know Kelbron. He'd never been to his apartment. So with these facts, it's undisputed that the defendant had no legal reason to be in Kelbron's apartment. The safe is in the very back area of the apartment, and the safe keypad where the defendant's fingerprint was found was something that the burglar necessarily had to touch. The safe was clearly tampered with as if someone was trying to break in. And then I just want to, some of the case law on this, the CCA has held that circumstantial evidence is frequently just as convincing in a criminal case as direct evidence. That's Greer v. State. I feel like we can prove this case through the circumstantial evidence. That's Gilbertson v. State, Judge. That's the CCA. Judge, as the fact finder here, you can make reasonable inferences from the facts that we presented here. The fingerprint being on the safe that was on the safe keypad that was removed from the safe, that necessarily had to be done by someone who was trying to break into the safe, Judge. And I think a reasonable inference from what we brought you to in this case, including the statement from the defendant where he says he didn't know the complaining witness, he'd never been to his apartment. I think it's a reasonable inference that you can make when he had no legal reason to be inside the apartment, that there was a burglary, Judge. The only other CCA case I want to mention is in Bowen v. State. Fingerprint evidence is sufficient to sustain a conviction in a burglary case. We can show that the prints were made at the time of the burglary. And I think based on it's a reasonable inference that you can make, Judge, when you combine how the apartment was ransacked, the door was busted open, and the attempts to enter the safe, combine that with the fingerprint and the defendant's statement that he didn't know the defendant, didn't know the complaining witness and had never been to his apartment, Judge. I think that's a reasonable inference from the evidence in this case. We believe, or Judge, we're asking you that you find the defendant guilty of burglary.
Okay. So I had a chance to listen to all of the evidence and listen to it with my mind towards what's in the indictment. So with the burglary of the habitation, first element is the date. I think you satisfied the date. I think you satisfied Bear County. So the only other issues are, did someone unlawfully enter a residence? And was it the defendant? So what you have connecting the defendant to this location is one fingerprint on a safe. And you have, from your witness's testimony, many fingerprints inside that apartment. That's what I recall from what the witnesses testified to. The problem is, with the fingerprint on a safe, with a fingerprint on a knife, with a fingerprint on a refrigerator, those are movable objects. And when I say movable objects, I know that the safe was nailed down or secured. Nobody knows when that safe was nailed down or secured. I know that the witness is stating that this defendant's fingerprint was on the keypad. Nobody knows when that keypad was put there. I know that the officer in State's Exhibit number 24A that was admitted said, "We have you at the scene. We know you were there." Where is that evidence other than this fingerprint that's on the safe that nobody can tell the court when that fingerprint was placed on the safe? Do we have a fingerprint on the doorknob? Do we have a fingerprint on any of the tools that people are saying that was alleged to have been used to illegally enter this residence? Those are all things that I look at. And I understand that inferences can be made. I understand circumstantial evidence. But in this case, the only evidence that's presented to the court is we have a fingerprint on a safe, on a keypad. That's all I have. I have on 24A that you have an officer saying this is capital murder case. Well, we're not here for capital murder. We're here for a burglary of a habitation. So that's what I have. And as both parties know, state and defense, when you come before me on a bench trial, state, if I think you've proven your case, I will find somebody guilty. Defense, if I think they have not proven their case beyond a reasonable doubt, then that person's going to be found not guilty. It doesn't matter in the sense that, oh, this is a murder case. Oh, this is a capital murder case. I'm just going to go by what facts were presented to me as a jury would. And it's what facts are presented to me. And in this case, with regards to the offense of burglary of a habitation force, I don't believe that the state has proven its case beyond a reasonable doubt. So I'm going to find the defendant not guilty. Is there anything else from either side? All right, we can go off the record. Mr. Romero, I wasn't at the scene on this day. I don't know what happened other than the evidence that's presented to me. You know who you are, and you know whether you did something or didn't do something. I always tell people, and I would tell my clients, when we go to a jury trial, if you're found not guilty, that's not saying you're innocent. It's only saying that the state didn't prove their case. And there are many times where the state may have a case and somebody's found not guilty. It doesn't mean that they're innocent. It just means that they didn't prove their case. That's it. When you go to trial, it's not, the first phase of the trial is not, oh, we're finding somebody innocent, we're finding somebody not innocent. It's, were they able to prove their case beyond a reasonable doubt? You know who you are, and you know if you've done something or have not done something. But what I'm going to tell you is, for the rest of your life, you have better decide what you're going to do and not come back to a felony court for allegedly doing something improper. Do you understand? Is there anything else from either side?
No, Your
No,
Honor.
Your Honor.
And state, Diana still needs that exhibit.
Yes, Judge.
Judge, will you sign the release so that he can get the monitor removed?
Is this the only thing that he has pending?
Yes.
All right. Can you all check the system? I know you all are saying this is the only thing that he has pending, but just to see if there's something else. Mr. Steinberg, can I see you for a moment? And Hank,
Yes, ma'am.
I know you all are not on Steinberg's case, but so it won't be considered ex parte. If you could come forward too.
Yes, ma'am.
Can you meet us, please? Not really nice. All right, Mr. Steinberg, if you'll come forward. And I believe you both had rested and closed, and you both, have you done your closing arguments yet? I think you did.
Yeah.
All right. So we're on the record in 2023 CR 5150, State of Texas versus Genevieve Nicole Lopez. If I gotta have parties announce for the state
Travis Bank.
defense.
Joe Stenberg representing Genevieve.
All right, you are Miss Lopez, correct? All right, the court has heard all of the evidence. And the court is prepared to make its ruling. As previously stated, the court is finding you not guilty of aggravated assault with a deadly weapon. The court is going to find you guilty of the lesser included offense, Class A misdemeanor, assault, family bodily injury. Are you all ready to proceed with sentencing?
State is ready.
Defense?
Oh,
And I can tell you, defense, I'm going to give her probation.
okay.
So would you all like to proceed with sentencing? All right. So, Ms. Lopez, if you can raise your right hand for me, I'm just going to ask you some questions to make a decision on what type of conditions to give you, okay? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. So do you have any contact with your children now? Do you have visitation?
Yes, but not enough, not a lot.
Okay, is that visitation through a court order?
No.
All right, it's just visitation. Does the complainant have custody of the children?
He, not court ordered custody, but he has them right now because I don't have a place to stay, so
Okay.
I don't want the kids, jumping around with me.
All right, so what is happening with housing? Why don't you have a place to stay?
Just not being able to make enough money right now.
Okay. So are you employed?
Yes,
What do you do?
I work at Murphy's Tomatoes, warehouse packaging tomatoes.
Okay. I've never heard of Murphy's Tomatoes. At first I thought it was a restaurant, but they just packaged
Yes.
tomatoes. All right. So are you living with someone or are you,
I'm living with my mom.
okay. Are there any other children in the household with mom?
No,
How far did you go in school?
I completed high school. I got a diploma and then I did some trade school for pharmacy tech.
So what is your dreams job?
It's actually changed into being a counselor.
All right, what steps are you taking to make that dream come true?
Well, before this whole incident, my kids were enrolled in SAISD and they had a program that I had started signing up for. They give you free classes
Okay.
for certain things. That was one of them for counseling.
Okay.
I just had to wait until that class was available, which
All right, and have you seen any mental health personnel? Are you still seeing them?
yes.
All right, and who is that through? Is it through Center for Healthcare
Center
Services?
for Dr. Williams.
Okay. Okay, all right, this is what the court is going to do. The court is going to sentence you. Is there any, I'm sorry, before I sentence you, is there any request for the jail sentence? I'm going to give her probation, but I need to give her an underlying sentence, counselor.
The state would ask for an underlying sentence.
All right, in defense?
Absolute minimum.
Okay. All right, this is what I'm going to do. I'm going to sentence you to 1 year in the Bear County Jail I'm going to suspend that and probate it for 1 year. So that means if you complete everything and you're successful, you won't have to do the 1 year in Bear County Jail. But if you don't complete everything, or if a motion to revoke is filed, you're looking at potentially 1 year in the Bear County Jail. You understand?
Yes.
There's going to be a $0 fine. There's an affirmative finding of family violence. I'm going to do 80 hours of community service restitution. Once you complete parenting classes, that 80 hours will be deemed to be satisfied. Probation, she's already with Center for Healthcare Services, but if you think it's appropriate to do a mental health evaluation, you can, or if you want to just have her continue what she's doing. So the mental health evaluation is just to make sure that you're receiving any treatment if you need it, all right? So we'll do the MIC, and she's to continue with Center for Healthcare Services. And I'm going to ask that you go to some type of trade school. So if you want to be a counselor, you can be a counselor. Some type of higher education, you understand? And if you obtain a certificate for some type of higher education or something that you want to study in or have as your occupation, if you complete that, I'll consider terminating you early, which would mean you would be off probation early, all right? There's going to be regular reporting, and she can report by Zoom or in person. We'll do regular UAs. And we'll do field visits 1 time per month for 2 months. If in that 2 months' time, there are no issues, then probation, you can discontinue field visits
After you said 2?
after 2 months. Probation is, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. With regards to your child visitation, is your mother willing to supervise those?
Yes.
All right. So no unsupervised contact with minors. Once you start on your parenting classes, let probation know. You come back and then I'll consider lifting the no unsupervised contact, okay? And probation, once she starts with parenting classes, once she's done 2 classes and they think everything is fine, then just bring it back to me and I'll consider lifting the no unsupervised contact. Probation, is there anything else? Ms. Lopez, is there anything else you need from the court for help? All right, Ms. Lopez, in this court, people who are on probation, they do very well if they communicate. So if there's an issue with probation, if there's an issue with you seeing your children or any type of issue, if you come in and let the court know, we'll figure it out. Okay. Counsel, I don't have the trial court certification of defendant's rights to appeal.
Okay.
So if you can get that, and then I will make a ruling on that.
The other thing is, I'd like to request some advice.
Sure.
We would like an expungement on affirmative, not guilty on.
On the aggravated assault? Oh, yes. Just if you, when they do the judgment, it's going to say acquittal on that. And then if you file the motion requesting for the expunction for that, because it's an acquittal, she gets it for free.
Right. And the other thing is, we're going to be filing a notice of appeal,
Sure.
but we'd like to go ahead and start what you just ordered her to do, so she'll be able to see her children.
Okay, sure. All right, so if you'll pull the trial court certification. You're welcome. Do you need more than one? Okay. And the cause number, council, if you don't have it, is 2023 CR 5150. And Ms. Lopez, I'm serious about communication. So if there are issues, do not throw up your hands and say, I'm done with everything. Contact your probation officer. If you feel like they're not addressing your issue or something else has come up, then let us know.
Thank you.
You're welcome. And does she want contact with a complainant, or I don't think they should have contact.
Oh, that's the reason we didn't do anything before, I think.
Okay. So what I'm going to do is I'm going to order a no contact with him. If he tries to contact you, just call your probation officer or call the police. And then if there needs to be child exchange, your mother can be the go-between.
The problem I have with the no contact is it states directly or indirectly, and she's going to have to arrange the visitation.
Oh, through her mom.
Yeah, but to me, directly or indirectly, you can't use your
No,
mom.
that's not what I'm saying. So this is on the record, what I'm saying. And what I can tell you is if her mom is the person who's going to be arranging the visitation,
Yes.
probation is not going to file a motion against her for having the mother arrange visitation. And what I can tell you, all the motions to revoke that I receive, I read them thoroughly. And if I have a question about why is this being filed, I'll ask probation and I'll have them pull the court's file and I'll be able to see what I ordered. So what I'm going to put on here is that there is to be no contact with the defendant. However, your mother can be the person to be the go-between for the child visitation.
Okay. Could it be my mother or his father? I have communication with his father as well.
It can be either one, just as long as you don't contact him directly.
Okay.
And I'll put that you are not to contact him directly. So if it's your mother, if it's his father, that will be contacting him indirectly, and that's fine. But the only way you can contact him indirectly is in regards to the children. Okay?
Yes, ma'am.
Here, if you'll step up here so you can sign it and write firmly.
So probation, there's to be no direct contact with Robert Courtney. Thank you, Mr. Steinberg.
Pleasure.
All right, did you review the document with your attorney entitled trial court certification of defendant's rights to appeal?
Yes.
All right, you do have a right to appeal because this was a jury trial. However, because there's an affirmative finding of deadly weapon, and because this is a conviction under an affirmative finding of family violence. Because there's an affirmative finding of family violence, and because this was a conviction for lesser included misdemeanor assault family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand? If you have a question over what a weapon or an ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Do you have any questions about anything? All right, if you'll speak to probation.
Thank you, Your Honor.
You're welcome. It's always good having you. All right, and can you make sure that there's the acquittal for Mr. Steinberg on Genevieve? It's just for the aggravated assault. Yes. Here you go. And what is happening on Cameron Moore?
I believe it was the judge.
All right.
Even the back and front was Mr. Cameron.
All right. So we'll take a short break. minutes. We're ready. Yep. Court is calling 2023 CR 5520, State of Texas versus Cameron Moore. Can I have parties announced for the record for the state? Defense?
Cornelius Cox.
Yes, come forward. Are you Cameron Moore? Counsel, have you received all of the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Moore, I'm showing you what's entitled application for community supervision or deferred adjudication. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, sir.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on count one and waiving, proceeding on count two, waiving count one, and then we weren't going to proceed on the deadly weapon enhancement.
Okay.
All right. Going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney?
Yes, sir.
Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Did you understand the state is proceeding on the offense of deadly conduct firearm as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, sir.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand that today by entering this plea, you were giving up those rights?
Yes, sir.
Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, sir.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, sir.
Mr. Moore, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, no, no.
Anyone promised you anything other than the plea?
No, no.
Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, sir.
According to the plea, state is proceeding on count 2. There's to be a $600 fine. They're opposing your application for deferred adjudication. They're recommending community supervision. They're taking in consideration 2023 CR 5563. There's to be restitution payable to Blaine, BLAINE, Sprayberry, SPRAY, BERRY, and you are to forfeit the weapon. Did you understand that to be the plea?
Yes, sir.
Defense?
Yes, sir.
State?
Yes, Your Honor.
Showing you waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
No, yeah.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your supervision be for a term of 8 years. There'll be a top evaluation, no contact with Stout, STOUT, Ice House, and Blaine Sprayberry. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to the offenses charged in count 2, how do you plead? Guilty, not guilty, or no contest? State any evidence
State all for State's Exhibit 1 and all attachments.
No objections.
showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. State, have you contacted the complainant?
So we have previously contacted the complainant. We did not notify him about the specific plea bargain, Judge. He was aware that it was a possibility. He voiced to us what he wished to have happen and still made the offer, Judge.
All right, and does the defendant have criminal history?
No, Judge.
All right, do y'all wish to proceed with sentencing?
Yes, sir.
All right, anything you wish to say on behalf of your client? Briefly?
Briefly, it's hard to be brief, but just for the record, Judge, his mom is seated in the back. You know, he's seems to be a good, you know, not somebody that goes out looking for trouble or problems. You know, we're aware just that sometimes these problems are created because just the mere fact that he's getting a weapon in the fight. But it appears that you know, my client had to go to the hospital himself because he was choked during the process. You know, while he was being held, choked to a point where they wouldn't even accept him at the jail because his eyes were kind of bulging out of his head. And that was his concern, his mom's concern. But he understands in talking to him the thing that he needs to do. He's expecting a child soon, and he wants to do something good with his life. So yeah, I can kind of say, based on my knowledge of him and dealing with him, he's going to be a model citizen after that. It's just a situation where something after he called himself trying to help a friend, and one thing just led to another. He didn't in his story, he didn't act point weapon, but once he brought it out just to kind of calm things down, but it didn't calm things down. So we just want
I've discovered weapons never calm things down. Weapons tend to escalate things.
Yes.
I just learned that from
So how old are you?
24 and on.
And this child that you have on the way, that's the only child?
This year.
How far did you go in school?
High school, but I thought about college. I just wasn't sure if it was for me because that's why I decided to just make my own LLC.
Wait, I can't hear you.
Just high school, but I was thinking of doing college, but I just never decided to because I wanted to do things like do something most people don't do, which is like come up without college, which is I made my own LLC. But I talked to my attorney, he's told me that I should actually just focus on college.
Sorry, sir, can you repeat what you just said you talked to?
Talked to my attorney, and he's recommended, he's opened my eyes to school to go to college for my business so I can actually do better in my business.
And this incident, what time did it happen?
2 a.m.
Nothing good happens after midnight. Sometimes when you're at your own home, things are not good that's happening at midnight. You know why? Because if you're awake at your home after midnight, that means that you have insomnia.
Yes, sir.
And when you're at a club and it's after midnight, nothing good happens. And I already know in this day and age, people don't start leaving their house till 10:30 p.m. to go to the club. Nothing good happens at the club. And you know what ends up happening? People usually start drinking before they get to the club. And then there's more drinking after the club. Then people lose their mind.
Yeah.
If you'd have been at home, you wouldn't even been here.
Yeah.
Do you live with your mom?
Yeah, I do, yes, for sure.
Were you living with your mom then?
No, I actually wasn't.
Who were you living with?
I was just staying at a friend's because I was just trying to he was helping me with my business. He's on the LLC as well.
Okay, you're gonna have to slow it down and open your mouth and speak up so the court reporter can hear.
My apologies. I was staying at my friend's house, but she's also in the business with me, the LLC, but it didn't work out either for him either, so I went back to my mom
Why didn't it work out for him either?
because they kind of like own a studio, so it was like they had like loud complaints and everything, noise complaints and everything. So and it wasn't something I wouldn't even want to be in certain situations no more. I think.
So you would prefer to leave your mom's house to go live at a studio apartment with somebody else?
Well, she only had one bedroom at the moment, so I just didn't want to impede on my mom as much as I've already her whole life, well, my whole life. So I tried to be on my own for a while, but.
But the problem is you're 24, you should be on your own. And now you're having a child and you living with your mom. That's not a good situation.
That's for sure. I'm working on it right now though, right? Because the girl I'm having a baby with, we're about to move out soon, like in a month or two, but the baby should be here in a month or two as well. So it's kind of like a race against time, but
Oh, yeah. And I'm sure both you and her are depending on the baby's future grandparents to, oh, you're not dependent on them for anything.
no,
Y'all already have daycare set up.
no, actually, I don't have that set up. But the only reason my mom wanted me to come back home to help me out because us staying place to place was costing too much instead of just staying at her home. That's why I'm here at that.
No, I mean, you've got to be an adult and you're not being an adult. Anytime you live with your mom,
Mhm.
I don't care if you're 40 years old, you're not grown, you're living with your mom. And so that means that your mom's rules apply.
Yes, sir.
And since you have a baby on the way, your mom and her maternal grandmother, they're supposed to just maybe babysit once in a while. They're not supposed to be raising your child. You understand?
I understand that now.
All right, this is what the court is going to do. Court is going to sentence you to 7 years deferred adjudication, $600 fine, that will be probated. Take in consideration 2023 CR 5563. There's to be restitution, if any, and no contact with, blame, Sprayberry, and you are not allowed to be at anybody's ice house, not just Stout Ice House. You're not allowed to go to any ice house or any place whose primary purpose is to sell alcohol. You understand?
Yes, sir.
You forfeited those rights.
Yes, sir.
So probation, yes?
I'm not too sure who Brian Sprayberry is. Would that be like at some point like
The
told to me?
complainant who's listed in here. So there's to be no contact with any ice houses or any establishment with a primary business is the sale of alcohol. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. 100 hours of community service restitution. I'm going to ask for parenting classes. Once those parenting classes are completed, the 100 hours community service restitution will be deemed satisfied. Regular reporting by Zoom or in person. And I'm going to want him to complete some sort of trade school or higher level education. And field visits one time per month for 3 months. And probation, if everything seems okay after that, then you can do field visits as you deem necessary. Probation is there. Oh, and he's to forfeit the weapon. And while you're on probation, you're not allowed to own weapons. You understand? Probation, is there anything else he needs? Is there anything else you need from the court to be successful on this probation?
No, Your Honor. I think you gave me everything I needed and more.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Oh, yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
We can go off the record. Here's the thing. So many bad things could have happened that night. I'm sure your mother was devastated when she got the news that one, you were at jail, and two, the jail wouldn't even accept you because there were medical issues. Do you know, a parent's worst nightmare, I've been told, is when their children go out and then they get a phone call that their child has been in an accident or something has happened to their child. You will understand that when you have your child. So what you did was a big disappointment to your mom, and you put fear in her heart. You understand?
Yes, Your Honor.
Do not do that again. Do not come back to this court for disobeying the court's orders. If there is anything that you feel is not being addressed with your probation officer, you can come to court and we'll address it. Do you understand?
Yes, Your Honor.
All right, good luck to you. You better do better.
Yes, Your Honor. I
And
wanna
thanks for dressing appropriately for court.
thank you. I want to thank you for letting me be able to see my son. I mean, his son, I appreciate you.
Oh, you're welcome.
Thank you.
All right, here you are.
Judge, I think that's it for us.
All right, and happy birthday month. You guys are welcome.